Hi, good evening. Welcome. How are we doing today? You know how we're doing, John. It's the middle of June. We're terrible. That's why you're here, right? You're going to make us feel better? Yes, I am. I hope. The goal of tonight, again, kind of piggybacking from where we were a few weeks ago when we saw each other, was to kind of just quickly, where should you be? Some overall priorities regarding MBE to focus on, where you should be going in the next week or two before we see you again in July. And then we're going to walk through a handful of questions, okay? Just kind of broad approach, not to get you with any law and all the particulars, just overall different kinds of questions from a few random subjects, just to overall, if you can pick up on anything you're doing too much of, not enough of, more generic reading comp approach kind of stuff, just to kind of give you a basic feel for when you make a mistake. The issue is always trying to fix the mistake. Most students right now, this time of year, as I joked a couple of weeks ago, what happened, you're pretty much living based on your number, right? You text somebody, you know somebody, you see somebody at school. How you doing today? 72%. How you doing today? 52%. You're pretty much living based on your stats. That's the good news and the bad news. The issue isn't the number as much as it is the why. Why? Why was I at 72 today? Why was I at 55 the next time? That's the problem, or the good and bad news. Most people don't fix the problem. They just do more questions. And they've done 1,500, 2,000, but their number never really moves a little bit because it's either the rule or, as I always say, the reading comprehension. So where you are is not definitive of where you're going to be unless you just keep doing the same amount of work without fixing the problem. So that's what we're going to try to talk about. So at this point, for most people, if you're doing the bar course, you're overwhelmed. You're either just took your simulated, you're about to take your simulated, it's coming up soon. Remember, you can't pass the bar or fail the bar in June, whoever you are. The only way you could fail is, again, by not kind of taking a step back and saying, okay, where am I? And of the subjects, that you really, when you look yourself in the mirror, say, I need to get a little stronger. I need to feel a little, I got to get a little more time to review more black letter law. They've been throwing tons of stuff at you for the last 2-3 weeks. It just gets to be too much. So it becomes this tsunami of law, and I got to get down to basics and focus more on my black letter law. Use whatever time you have before and or right after your practice test to kind of say, okay, enough with the minutia, enough with the long outlines. I just got to get back to black letter law. And as soon as you put some rules in your head, again, what's John's approach? Always be reciting black letter law wherever you are, in the car, doing the errands, watching a little TV, online at Starbucks, wherever, going to work, coming home from work, on the train, off the little rule. You can't do the whole outline every day. You can't do 7 outlines every day, but you can do a few tort in the morning and a few primes in the afternoon and a couple of hearsay exceptions at night. It's not all, but 7 days a week for 6.5 weeks, you will be stunned how much more law you're really going to retain. And then better comfort with law makes you more confident when you read the questions. If you're not sure what the heck's going on, it's because you don't know enough of the rule, and then you make a lot of the reading mistakes. It really is a cause and effect. So this time of year is not about just going and doing 100 a day to fix the problem. It's not going to fix the problem. It's going to make it worse. I got to get back and put more law in my head. For my repeat taker friends out there, again, this time of year, either you get a little nervous because you're feeling some of that deja vu feeling, and if the number isn't improving, it's because maybe you're either trying to push too much of the minutia and not focus enough on black letter, or you're feeling pretty good about the black letter, but again, you're not focusing enough on the reading comp. A little bit of both goes a long way. And that's what you always want to be talking about. So when you miss a question, don't worry about, oh, I wanted it to be green, it's red. Why did you miss it? In that first 2 sentences of the explanation, you should know that you forget or confuse a piece of the rule. Okay, I can write that down. I shove it back in my head. I run around the house and I say it 50 times. And the more you speak, the more it will sink in. No, I knew that rule, John. I missed it because I screwed up the reading. I read too quick. I read too slow. I overanalyzed. I, God forbid, changed my answer. I didn't spot the issue like you're always saying. I'm getting a little lazy with my reading. You're right. I got to do fewer and be more focused on how I'm reading each one of these questions. As long as you see that, you will be shocked how that number will begin to go up. And by the middle of July, you gain that consistency. So always be going back right now, this next week or so. I always like to say this time of year, think about a month ago. bar prep started, or you began studying somewhere maybe in the middle or the end of May. Think how much you put in your head in the last month. A month from now, think how much practice you can do with all that time, and you'll still have about another 7, 8, 9 days before your actual bar exam. So it's still plenty of time. I always say the first half of bar prep is about the law. The second half of bar prep is about the practice and gaining that consistency and balancing MBE with your state portion. So once you're feeling pretty good about the law with MBE, my recommendation, broad advice is a good mixed set of MBE 7 days a week. How many, John? That's the ultimate question. There's no right number. 5 or 10 too few, 50 to 100 too many right now, 25, 30, 35, 40, just enough so you're seeing a mix of questions. If you're good with the law, if you're good with all the law, if you've done 3 subjects, 5 subjects, 4 subjects so far, a little mix set on the ones you've already done, and then you add in the other subjects as you are completing them. But a little mix set every day, just to make sure that you're seeing a little bit of everything. Your brain's going back and forth. And yes, I recommend doing them in practice mode now. Leave the exam mode for July, because you want to learn from these mistakes as you're doing each question. Okay? Big picture. Black letter, feel a little better. Reading comp, feel a little better about that. Let's walk through some and we'll see what we're talking about. Okay? Here we go. Again, these questions are on the NCBE website. We're doing these with the permission of the National Conference of Bar Examiners on the NCBE, ncbex.org is the National Conference of Bar Examiners, and they have these test questions on there, these sample test questions. So we're just doing a sample of the sample, if you will. This is number 4 of there, but we're doing it with their permission, and you can go on the NCBE site if you wanted to and check these out. So let's talk about this kind of a question, okay? Here we go. Big picture, macro. A lot of people like to look at the call, okay? Go ahead. So here's the problem. You read that question and you say, could be tort, but you don't know what tort, okay? You look at the call. In most of these questions, the call of the question really doesn't tell you the particular rule you're being tested on. That's the problem. I know a lot of you have been trained, look at the call. Here's my problem with that. This, in a suit against the man, is the neighbor likely to prevail? No, no, yes, yes. You have no idea what issue the question is about. So if you go down to the answers under the theory, let me see what they gave me, John, you're now going to put 4 ideas in your head. But how many rules or issues is each question testing you on? 1. So I say rhetorically, why do you want to be thinking about 4 things when you're only looking for 1 thing? That's the key. So you're saying I shouldn't look at the, I didn't say that. I said, if you go from that question down to the answers, you literally do not know what you're looking for. What do you need? What's the most important part of every single question, all 200? The facts, the facts, and the facts. Most students read too quick. They're skimming because they want to see the answer. They want to see if they're right. And then that's why their answer has nothing to do with what they're being tested on. That's why when you look at the explanation, oh, of course, that was stupid, John. Oh, of course, 5 more seconds, I would have seen what was going on. Take the 5 seconds when you're doing the question, not after the fact. Slow the bleep down. So if you like to look at the call, go ahead, but then make sure you're focusing on the facts. You still feel like you're a little all over the place, I would recommend maybe trying the facts and then the call, because it's kind of focusing, it's pushing your attention on the facts where everything is, where all the details are. The one sin of this is you do not want to look at those answers until you know what you're looking for. So don't look at the answers, just read the 4 or 5 line fact pattern. I'll be quiet, and then we'll pick it up from there. Just read the facts. Okay, so I love this question because this encompasses a lot of different things that I talk about and teach about MBE test taking all over the place. A, call the question doesn't do anything for you. I need the facts. 2, issue spotting. What's the issue? A dog injured somebody. in a suit against a man, will the neighbor prevail? And the issue is a dog injures somebody. It's a tort question. What tort? What issue do I think about when a dog injures somebody? Strict liability. Wild animal, domestic animal. You should walk yourself through this, nice and slow. This is the marriage of the law and the reading comprehension. But John, usually a dog is a domesticated animal. That's true. So usually it would not be liability. It would be no strict liability. But what does the rule say? Can a domestic animal become a wild animal for MBE purposes? Yes. If the animal has dangerous propensities. If it's the bad dog, if it's the bad cat, can the domestic animal become wild? Yes. Is that what's going on here? Yes. Is this a bad dog? Yes. Is this a ferocious dog? Yes. And you know it's a ferocious dog because the facts told you. That's exactly right. Slow the bleep down. Because if you're skimming, oh, dogs, that's not a wild animal. Got it. Wrong. Why am I wrong? Didn't read the facts carefully enough. So wild animal, usually not. Here it is. Strict liability. There's going to be liability. But is that where the facts end? No. Is there a legal defense to either form of strict liability, whether it's animals or abnormally dangerous activity? Yes. And what's that called? Assumption of the risk. Now, let's talk test taking. And this applies to all 7 subjects. Crim Pro with the exceptions of search and seizure, evidence, the whole subject. I tell you, never pick a defense or an exception to a rule unless you're sure that that's what the fact pattern is talking about. Because the answers that quote or define defenses and exceptions are legally true. There's nothing wrong with them. But the reason they're not correct in most of those questions is because that's not what the hype was talking about. Assumption of the risk. You know and appreciate the nature of the risk, and you do it anyway. So knowledge alone is not enough. You have to know and understand, appreciate what you're getting yourself into, and then if you assume the risk, there's no liability. Is that what happened here? Yes, because there wasn't just a sign. Did the man read the sign and know what the hell was going on? Yes. So notice they never said the term strict liability in the facts. They never used the term wild animal, dangerous propensity, and they never used the term assumption of the risk. This is all what we call issue spotting, and you only would have picked up on all those little points had you slowed down and read the facts. If you did the dog injure, okay, let me see. Now you're looking at answers that have nothing to do with the issue. Strict liability, usually a dog isn't. Here it is. Usually the defense doesn't apply. Here it does. Facts, facts, facts. So what does John say? You're trying to go into the answer choices knowing what you're looking for. Not just whether I'm going to win, not the conclusion, the why. Because if I always have 2 yeses and 2 nos, 2 guilties, not guilties, constitutional, you get my point. If I always get down to those 2, this is not good news. This is bad news. Because if I'm looking for the 2 that come to the same conclusion, you will see that the 2 that come to the same conclusion are never discussing the same issue. That's the dirty little secret. So it's not just win or lose, it's why. What does John always say? You're trying to connect the dots. Whatever the most specific answer is to the facts, whether I agree with it or not, that is always the correct answer. So in this example, what are you looking for? I'm going into the answers looking for something that says, no, because the guy assumed the risk, right? That's what I'm looking for. So now let's take a look at A by itself. Don't read all the answers, read A. Notice that A does not say, no, because the guy assumed the risk. They're not giving you the buzzwords, the legalese. That's what everybody also is looking for. But many, many, many times on these questions, they don't give that to you. That's why some students say, I'm looking for the words assumption of the risk. If I don't see it, John, I think they're trying to trick me. Okay, but is A basically in plain English saying what you were looking for? Yes. Take a look at B. Now, this is what I teach. How do I contrast the 2? My language, do whatever is comfortable for you, is I'm always saying, what is each answer about? Every answer on the bar, no matter the subject, is referencing, talking about, mentioning a buzzword, whether it's in the legalese or plain English, about a tort, about a crime, about an amendment. Hundreds of these answers are legally correct statements of law. The reason they're not the correct answer is because they have nothing to do with the issue. If you can't, what I call, connect the dots. If I'm doing a strict liability assumption of the risk hypo, my answer has to be about that. Any other tort, any other crime, any other issue, even if legally true, is never the correct answer. So if this was a tort essay, could I always argue trespass? Absolutely. But what the bleep does trespass have to do with strict liability / assumption of the risk? Absolutely nothing. And what sound do I want to hear when you read an answer that, even if you like it, has nothing to do with the particular issue? Take that number 2 pencil and cross it out. Don't put a little star next to it. Cross, you know that B is wrong. Can't be. I can't pick a trespass answer to a strict liability assumption of the risk issue. I can't. So notice that A and B come to the same conclusion. But are they talking about the same torts? No, they are not. Take a look at C. What interesting buzzword did they give you in C? Invitee. Invitee, licensee. When do I care about whether someone's an invitee? The duty thing, John, when I have a duty. And when do you care about that? Oh, negligence, invitee, right, the duty of care with negligence. Yeah, he is an invitee. Who cares? Are you going to pick a negligency duty of care answer to a strict liability question? No. D. Yeah, it's a nice juicy buzzword about strict liability, John. Notice, sit back, see the big picture. Notice how notice C and D both said yes, but they were literally talking about different issues also. Even if you get it down to the right conclusion, you contrast what's the difference between the two. But you don't really care as much about the conclusion as the why. So you're not staring at A or B or C or D for that long. Notice the second thing. In B, C, and D, notice how they gave you buzzwords in all 3 of those answers. Notice A is the only one that's written in plain English. But yet, is that the correct answer? Is that the most specific to what the facts were all about? It didn't say the term assume the risk, but that's where they were going. Sometimes you will get the buzzwords. Absolutely. It's just I'm more concerned about when they don't give it to you. Too many students think, I need the answer to look like my car, John. And if I don't have the buzzword, I'm only supposed to pick the best legal answer. No, that's correct in that you're supposed to pick the correct, most specific legal answer to what the issue is about, not the best legal phrase. Because if you did it that way, you'd pick consideration to every contract question. Because without consideration, John, there's no contract. Makes sense. That's why every time you do a search and seizure question, there's always an answer about exigent circumstances or consent. They give you the exception. But if there was no exigent circumstance, doesn't make a difference. Just because the answers could be legally true does not mean automatically they are correct. So here, what are the takeaways from something like this? Issue spotting. Facts are the key to every single MBE question, no matter what the subject. Don't skim. The timing issue. Let's talk about that for a second. If you skim the 4 or 5 lines to get to the bottom, you're going to have to reread it because you're going to be thinking about 4 different torts here. I'm saying flip it around. If you have the proverbial 1.8 minutes, minute and 45, minute and 50, something like that, think of it this way. If I take a minute and a half, which is a large amount of time, you wouldn't need anywhere near that for this question, but I have it if I wanted to. If I took a minute and 30 seconds and just kind of, okay, it's an animal, strict, you walk through it like I just did. Now I know what I'm looking for. I'm looking for something that says that he didn't do it because he assumed the risk. How fast could you fly through B, C, and D and know that A is the correct answer? 5 seconds. So you're still going to be done on time, but you're going to be correct. Don't sacrifice accuracy because of time. Time, it's not a speed test, like I say every time I see you. It's an accuracy test. You're trying to get more right. So if you slow down for an extra 30, 20 seconds in the facts, you will not only know that A is correct, you should be able to see why B, C, and D are wrong. And that is the key. Always be asking why the others are wrong. And generally they are wrong because they are factually or legally irrelevant to the issue. Beautiful. All right. Let's take a look at another one. You know what? I'm going to skip this one for now. We may come back to that. That's a property one. You're going to be too upset to do property so early. You're right, John. Good call. Let me build my confidence with something else. Okay. Here again, look at the call, the facts in the call, but do not look at the answer choices. I'll give you a moment and then we'll walk through this one. Okay. Here's the opposite example. They told you what the crime is. They're clearly making the issue about murder. See, John, this is why I like to look. Okay, let's flip it around. Notice the first one just said A sues B for their damages. Didn't tell me. Here they told me. In many criminal law questions, it says, is John guilty of larceny? Is John guilty of burglary? Is John guilty of murder? But even if they tell you and you now know the name of the crime, you don't know whether I did it or not unless you read the facts. More importantly, for murder, as an example of many other crime and other issues, at common law, which is what the test is about, unless they tell you otherwise, how many forms of murder are there? 4. Intent to kill, intent to inflict serious bodily harm, felony murder, depraved heart murder. So notice, it doesn't say the president was convicted of felony murder. It doesn't name which one. So that's what they usually do with these. If it just says the word murder and there are 4, I can't go looking for the answer choices because I don't know which one they were talking about. But if I read the facts, I know. What else do I know? If I know it's a question about murder, what answer can't I pick? What has nothing to do with murder? Manslaughter. Just like if I'm doing a strict liability question, I can't pick anything about negligence or trespass. If you know the issue, you not only know what you're looking for, you know why other answers are wrong. So you're telling me, John, once I see it's murder and I have a decent idea about which one it is, any answer choice that's talking about another crime, another rule, or manslaughter can't be the right answer. It's exactly what I'm telling you, which is the power of knowing the minimum black letter law, and then I can focus all my attention on the reading. So I see murder, I think 4, okay? What did the guy do there? Is this intent to kill? No. Is this intent to inflict serious bodily harm? No. Never infer intent. Is it felony murder? Is he doing any one of those dangerous felonies? No. Is it depraved heart? Did he know or should have known that something bad could happen and he did it anyway? Looks like it. What's reckless mean? Reckless disregard of human life. Knew or should have known, and you did it anyway. The strong likelihood. Not intent, not intent. Depraved heart, recklessness. Once they make this about murder, my answer has to be about one of the 4. That's the rule. Let's take a look at the answer choices. Take a look at A by itself. What does murder have to do with strict criminal liability? Nothing. What sound do I hear all over the country? B. Even if I disagree, why should you like B? He's talking about reckless, John. That's the murder I think we're talking about. I think I could connect those dots. C. What is a regular? I don't know what it is, but I know what it isn't. It's not a form of murder. D. Now, this is what I'm trying to get across from this webinar. Proximate cause, proximately causing a death. Proximate cause is an element of negligence. If you act negligently and cause a death, what should I be thinking about? Involuntary manslaughter. Can I ever pick an involuntary manslaughter answer to a murder question? Unless I'm an idiot. Exactly. Notice what they did. They gave you A and C, which are irrelevant to anything relating to this. If you could have gotten it down to B and D, why can't I pick D? because what is D about? What is D referring to? Proximate cause, breaching a duty, foreseeability. These are all negligence terms. And if there's a negligence term and a death, they want you to be thinking about involuntary manslaughter, which has what to do with murder? Nothing. This is why I say in every subject, when it says the president was convicted of murder on appeal, he argues his conviction should be reversed. Should the conviction be reversed? They're not really asking you some sort of an appeal question. Don't be literal and don't be a lawyer. I think it should. Let me look at the yes answer. That's in here, right? I always joke, if you're picking an answer and you say, to me, John, in my mind, John, you're always wrong. It's all based on the facts. So if your answer is based on, even when you're wrong, that's what it said, John, so that's what I went with. Okay, great. You're going to pass the bar. You'll give them these 35, you'll take your 65, and you'll be a lawyer. You can't get them all right, but that's excellent approach. So what is that about here? They made it about murder. I think it's about reckless. It's a weird example of the brave start, but look what they did. They only gave you one answer remotely on point to any form of murder. So that's why I also say, even when you disagree, I'm not sure, what do you need to do? Connect the dots. If they make the question about murder, which they did, my answer must and shall be about one of the 4 forms of murder. And since it was a little bit of a weird hypo, what did they do for you? They gave you 3 answers that had nothing to do with murder. Shut up and pick B. 2 of them were totally irrelevant, and D was trying to confuse you with the manslaughter, which is what happens this time of year. People get confused between the reckless and the negligent, which is why John's saying, and I saw it tonight again, keep everything separate. If you forget, what do? Okay, involuntary manslaughter, negligent. Depraved heart murder, reckless. You say that 15 times a day for the 3.5 seconds it takes to say it, eventually it will stick. And you do that with 100 more rules between now and the end of July, you'll be getting another 15% of these questions correct. So again, big picture. Here they gave me the name and the call, but I don't have enough information. I still need the facts. The last one was no information in the call. I for sure need the facts. What's the common denominator? I better slow down and read the fact pattern better, so I know what answer I'm looking for. And maybe I need to be what I call a little more mechanical with the answer choices. I'm trying to maybe get in my own head and analyze the answers. Don't what I call litigate the answer. Just play connect the dots. Think of these questions like a little puzzle. That's what they're talking about. That's not, that could be, that's not, shut up and pick C. It's not an legal essay writing. There's analysis. MBE, none. You go based on what that fact pattern said, even and especially when you disagree. Connect the dots. And not just think, I think B is okay, but I know that A, C, and D are wrong. And again, notice that even if I got it down to the 2 no's, A and B are not talking about the same crime. C and D are not talking about the same crime. They're always thinking about contrasting, not comparing. There aren't 3 good answers, and you have to find which one's the best. You're trying to find the most specific answer to the facts. Okay? Whoop, there we go. Sorry about that. A little bit of a delay. All right? Take a look at this one. Again, take a look at the facts and the call, and then we'll talk. Don't look. Okay, so again, another example. Civ Pro, they do this a lot too in Civ Pro. They may give you a lot of stuff. Sometimes there's a lot of moving pieces in the Civ Pro questions, but then generally they're going to pretty much give you the name of the rule. So here they're basically asking about judgment as a matter of law. Okay, what do I need to know about judgment as a matter of law? Okay, rule. I know what they're testing me on. What's the rule? What do I need to know? Whether a reasonable jury has enough evidence. Reasonable jury has enough evidence. Pretty much what it's about, right? So I go back in the facts. What is it saying here? The guy stumbles into the in a drunken manner. He refused service, so they ask him to leave. After leaving, he goes across the road toward a liquor store. As he's crossing, he's struck by a car, blah, blah, blah. The man sues the tavern for his personal injury. Those are the facts set out. Both parties move for judgment as a matter of law. How should the court rule? Is there any evidence whatsoever that the tavern, that the man is suing the tavern? What are you going to say as the tavern? We didn't do anything wrong. Is there any evidence to show negligence on the part of the tavern? No. In fact, did they do everything right? Yeah. Now I know what I'm looking for. Remember, I'm still trying to make sure that I'm connecting it to the most specific answer. So take a look at A. So they get you a little bit with the juror language. But what to look at A? Because reasonable jurors could conclude that the accident was foreseeable. That basically contradicts the facts. So sometimes they bait you with the right words and you just skim, oh, juror, that's it, reasonable jury, got it. And you're not looking at the one most specific to the facts. From this fact pattern, both parties are moving for a judgment as a matter of law. A reasonable jury that would not have any evidence to find out that the tavern did anything wrong. A baits you with the right word, maybe, but not specific to the facts. Take a look at B. Utter garbage. C. Looks pretty good. Take a look at D. Nothing to do with the definition of judgment as a matter of law. So when you get into the, I like that one better, I like the way it's written, I don't know about that. We've all done, right? You play that game when the little voice in your head is trying to interpret. This is why John's preaching on as many questions as you can. You're trying to go into those answers knowing what you're looking for. If I'm doing a judgment as a matter of law question because they made it about that, my answer has to be about the elements of judgment as a matter of law. A reasonable jury would not have enough evidence. Do they have enough evidence for the against a tavern? No. Which answer is the most specific? C. Shut up and pick it. Notice they're B and D, totally irrelevant. Again, notice deny, deny, grant, grant. You have two answers that come to the same conclusion as usual, but those two that come to the same conclusion are never talking about the same issue. If you said, oh, but it's about the jury thing, John, A mentioned juror, C didn't talk about jury. Yes, but the rule is that a reasonable jury would not have enough evidence. You don't want to latch on to just one word. So if you got it down to A and C, because both answers had something to do, again, that's where I'm going. The first couple we did, there was literally only one answer remotely on point. Here, you could argue that A and C are both talking about referencing a reasonable jury having enough evidence. When you get it down to two, and they are both about your issue. Yeah, I think A and C are both about JMOL, John. What will they do? Those will come to opposite conclusions. And if you're staring at A and C, what does it mean? If I know the rule and I know both of one of these is the correct answer, what should I do? Stop staring, go back to the facts. Because if they're both, if it's going to be guilty, not guilty, admissible, inadmissible, deny, you know what I mean? If you have opposite conclusions, the only thing you didn't do, you didn't pay enough attention in the facts. Somewhere in that fact pattern, you should have seen reasonable jury isn't going to conclude. There isn't enough evidence against the tavern in the first place. When you got it down to two, and you know what the issue is, right? It's a larceny question. I'm skipping around. Guilty, because John has possession of the watch. Not guilty, because John did not have the intent to steal the watch. Those are two larceny answers. Got it down to those two, John. How would I know which is the correct one? Did I have the intent to steal or didn't I? That's not from staring at the two. That's from going back to the facts. Do you have time to do that? Heck yeah, because otherwise you know what's going to happen. You're going to stare at these two and go eeny, meeny, miny, mo, and after 2 minutes, you're going to get nauseous and pick a stupid answer. If you take 30 seconds and go back in the facts, he didn't intend. D, done. Have the confidence, have the patience, have the discipline. I got to go back to the facts. Let me see the facts. Don't worry about slowing down. You want to get more right. Then speed kicks in because your eye begins to get more focused on the facts anyway. Good? Good. Okay, let's go back. Take a look at number 13. Notice here's the opposite. That's why I love con law. Notice the call of the question in this one. Is the law constitutional? At least I know it's con law, John. Oh, okay, great, fantastic, good. But you're going to be able to know that from the facts. B, you notice again, is it constitutional? It's con law. Let me just take a look, John. That's what people want to do because they know instinctively, subconsciously, is the law constitutional? Doesn't tell me anything. The last place you want to look is the answer choices because it's going to put too many crazy ideas in your head. It's 3 lines. Go read the facts, please. Don't look at the answer choices. Okay? Speech. First thing you should think of with speech, content-based, content neutral. What's content-based? Content-based is they're trying to what I call shut the message down. Deny, reject, prohibit. You want to march, advertise, display, parade, any, and the government's basically saying, no, you can't. That's content-based. They're just shutting it down. And what does content-based regulation trigger? Good. Strict scrutiny. Sometimes they're saying no, but they're saying no, comma. No, but you can do it over there. No, but you can do it over here. Right? No, but. You're giving the time, place, and manner restrictions. So you may not do it where you want and when you want, but you can do it someplace, another time, another place. They're giving them an out. And that is generally constitutional, meeting some form of intermediate scrutiny, but there's crazy words in there. What happened here? Is this content-based or content neutral? Well, it's clearly good, content-based. They're prohibiting any. They can't do anything. I got that from reading the facts. That's the key. Not is it constitutional? I think it is. I don't think it is. Issue. This is content-based. Content-based, strict scrutiny. Now I know what the answer looks like, no matter whether it says no or yes, because many times you're going to disagree with the conclusion, but you want to shut up and pick, again, always the most specific to the issue. So if I see you can't do anything, I got to think content-based. That's strict scrutiny. Now I'm going in knowing what I'm looking for. Take a look at A. Please. B. Does B look better? Why? What buzzwordy phrase is in B? Necessary to serve a compelling interest. That's the definition of strict scrutiny. C. Thank you. D. Come on. What's the most specific answer? Be beautiful. There it is. Notice how wordy those answer choices are. You've seen many others where the answer choices are like a paragraph long. This is why I'm telling you, don't get caught up in the muck and the minutia of all those words. Just say, what is each answer about? That's content-based, that's strict scrutiny, that's intermediate, that's rational, that's commerce clause, that's privileges. Every answer is about something or it's total garbage. And some of these answers were total garbage. They were just stuff you'd argue on an essay. Specific issue, connect the dots, reading comp. Even and especially when the call of the question doesn't tell you anything, you don't care. You're focusing on what the issue is from the facts. You're not going down there to make up the best argument. You're focusing on the facts. I know my rule. And again, I'm saying, if you miss any of these questions and you forgot the difference between content-based, content neutral, okay. If I miss it because I don't remember the rule and I read the explanation, it gives me that nice little definition. I forgot that, mark it down. Okay, now I got to make myself say it. You knew it, but you read too quick. That's a reading comp mistake. You don't care about the minutia of the law. You want to go back to focus on the facts. Period. Good? Good. Okay, hopefully we have a little more confidence now to try the property one. Now, before you start, I hear you moaning all over the country. Stop with the moaning, okay? Stop with the moaning. Remember, John's telling you, the longer, the weirder, the more you dumb it down. They're not testing you on 15 rules. They're not going to make you use a calculator for this. They know you can't do that. They know that. You try to dumb it down as best as you can. Think of the word. If you want to chart something down as you're writing, I think that's a good idea. You don't have to, but I think it's a good idea. Remember, it's not about the minutia. It's about the words, the buzzwords, the issue. Please read the first paragraph and then stop. Okay? Forget the money for a second. What happened? The woman took out a mortgage. Then she sold the land, the farm, excuse me, to a man. The man paid, and what is it? This I see mortgage, then another sale. What am I thinking? When someone buys your land and you have a mortgage on it, they're either going to assume the mortgage or take subject to the mortgage. The default rule is you generally take subject to the mortgage, which means if you buy land and there's a mortgage on it, you accept no financial responsibility to make the mortgage payments. But if you assume the mortgage, then you are primarily liable. You're assuming all rights and obligations on the mortgage. And how will you know when the guy assumes? Because they will. That's why they're reading compass. Oh, this is numbers, John. I'm never going to get this. Bleep the numbers. Focus on the words. The woman took out a mortgage. Now she's selling it. Issue spotting. She sells it. The guy usually is going to take subject to. But did this guy assume the mortgage? Yes. And you know he assumed the mortgage because they told you. Good. What then happened? Read the next sentence. Now, read the next paragraph. Is the guy on the hook? Is the man liable to the bank? So, big picture, what's my rule? I got to have the rule, then I can focus on the reading. Normally, if I assume your mortgage, I become primarily liable. If I don't pay, can the bank come after you secondarily? Yes, unless there's my favorite word, novation. And novation is a release from any liability. When I teach these classes, I say, never assume there's a novation. Make them tell you. Did they tell you literally here that the woman is being released, that there was an ovation? Yes. So right away, what do I know if it says the bank released the woman? That just means she's off the hook. Is the guy now totally on the hook because he assumed the mortgage? And you know he assumed because exactly. Forget all the garbage. Stick to the definition as best as you can. Use the buzzwords to help you. Again, I'm going to pause. If you forgot the difference between subject to and assume, no big deal. I go back into my outline. I shove the rule back in my head. If I know what it is, because I have it written down, but I'm too intimidated by the numbers, oh, I'm never going to figure this out. Is the man liable? Let me just look at the answers. Now you're giving up on the question. Give yourself a chance with the facts. And what John says, dumb everything down into plain English. She had it. She had a mortgage. She sold it. He assumed it. So I think you can go after the guy and then you can go after her. But now she was released. Okay, so you just go after the guy. So are we left with the fact that the guy's on the hook? Because did he assume the mortgage? Yes. So basically he's on the hook even though she was, exactly. Take a look at the answers. Now, I always get this question. John, if I know the answer, I know you say don't focus on the conclusion, but if I know the answer is a yes, can I just look at the two yes answers? Maybe by the bar exam, you're going to get more proficient and more consistent. So you could, I recommend for now, you still want to go A, B, C, D, because you're still going to go fast. You know why it's right or wrong. And it's also, I think, a great review of the law. If you're more sure of yourself to prove to yourself why A and B and C are wrong, you know you can end up with D. So you take a look at A. B. Is that even legally correct? No. C, what is clogging of the equity of redemption? I don't know, but I know I'm just going to get clogged up from not getting questions right if I don't read these correctly, because that's the one. That's why I like doing this question, because that's the one that puts the doubt in your head. I don't know what clogging around. I think there's something in the pen. I don't know. And you always want to pick the weird one, because take a look at D. Isn't D the most specific to what the issue is about? Yes. And if I got it down to two, and I know it's yes, notice the difference between C and D. I don't understand C. It's not about redemption, John. It's about the fact that the woman was released, and now the guy's the only one on the hook. And isn't that what D says? Yeah, but I'm afraid, John, when I see something I don't know, then I always think I'm getting tricked. I understand that's what I'm here to do. Stop that. Always pick the most specific answer to what the facts say every single time. When could I pick C even if I didn't know what it is? Good question. If you know, and I mean know, if I know that A, B, and C are wrong, or in this case, A, B, and D are wrong, okay? I'm reading this property question. I don't really get it. I've never seen it before. It's just a weird question. And I know that A, B, and D are stupid. And C is the only one that could be the right answer, even though I don't understand what it means. Then shut up and pick C. But that by definition means that I know why A, B, and D are wrong. Then I can pick the weird one, even though I don't understand it. You with me? But I know here, this was about the fact that she was released, so he's on the hook. Where is the most specific, even though two always come to the same conclusion? Answer choice D, delicious. Shut up and pick it. The call just said deficiency. Wouldn't tell me whether he assumed or took subject to unless I read the facts. I always need the facts to focus on what this is all about. So let's quickly review. Okay? Big picture, macro. Can't do any of these consistently if I don't know the name of the issue. Most of the questions in the call don't tell me anything. If they do give me the name of the crime, the name of the tort, the name of the rule, I still don't know whether I'm liable, guilty, or admissible unless I read the facts. You pick how you like to do that, in which chronological order, but you don't want to go into those answers until you know what you're looking for based on the facts. When you look at those answers, try, and these are my words, do whatever is comfortable. What is each answer about? And I have to pick the most specific. If I did get it down to two, and they were both battery answers, larceny answers, hearsay answers, only one is going to be specific to that fact pattern. That is the key. You reduce the reading mistakes. If you slow down on the facts, you'll go faster through the answers. You won't have a time problem. If I still have it down to two and I need to quickly scan the facts, you have the time to do that. No problem. I still want to get more correct, not be the first one done. If you've done it, looked at any of these, and you see that these are the kind of problems you have, I am still getting it down. I'm reading too fast. I just need kind of more of a refresher regarding more detailed approach. Hopefully, you know a little bit about me. I hate sounding like a used car salesman, but this is that time of year, and that's what we wanted to walk through some of these as an example. There is a detailed video on Adaptivar on the video page called Mastering the MBE. That's me doing what we were just doing in much more detail for about an hour and 20 minutes regarding approach, reading comment. I'm not doing any questions, just made up a couple of hypos, but I'm really talking about issue, why are the other answers about, getting it down to two, call. So if you think you just need to hear more of this in terms of approach, instruction, that video could offer some more detailed tips. You feel you're on the right track, but bar prep or too many questions got in the way. I just needed this to kind of refresh and kind of get me back on track. Thanks, John. I gotta slow down. I can't be worried about how many questions I'm doing. I gotta worry about getting more right. I gotta slow and be more careful in the facts. I think I'm beginning to doubt what I'm reading. You must trust the facts. You know, there's one of the great tennis players of all time. Maybe some of you heard about it or saw it. Roger Federer, one of the greatest players that ever lived. He just gave the commencement speech at a college last week, and part of the speech went viral. Everyone's going crazy about the part of the speech where he said, effortless is a myth. Effortless is a myth, because he was so great that the people used to say, doesn't even look like he's trying. He's making it look so easy. It's amazing. And he was always offended by that because people did not realize how many thousands and thousands of hours of practice went into making it look effortless. It's a great metaphor. I love what he said, that he asked the audience or told them he played in over 1,600 matches in his career. You know what percentage of matches he won? 80%, which is phenomenal. What a winning percent, 80% of all those matches. But here's the goosebump moment. You know how many points of the matches he won overall? Only 54%. He won 80% of the matches, one of the greatest players that ever lived, but only won a little more than half of the points. What's the point? He said, when someone hit a shot past me, when I hit a ball out, when I double faulted, I just kept saying, it's just a point. It's just a point. I lose a lot of points. I'm just trying to win the match. One of the greatest players in tennis was 80% successful in winning, but only winning 54% of the points. My point is, you're going to make a lot of mistakes. It's about the next question, about the next question, about the next question. All you're trying to do is pass. And passing is not anywhere near 80%. So you could make tons of mistakes. Just focus on the rules you can know. Focus on better reading comprehension. Slowing down in the facts so I see why more answers are wrong. If you just reduce 1 or 2 or 3 silly reading mistakes every day, that would make a huge statistical difference in your overall performance. But when you're getting anything wrong because of the law, I forgot that rule, I forgot that definition, don't freak out. Put the rule back in your head. Now you're guaranteed to get that again. You know the rule, but you missed the assumption of the risk. You missed it. You can star it, flag it. And once a week, on the weekend, on an evening where you may have a little more time, make some time on the weekend and review some of these stupid, silly reading errors that you say, man, if I just see that word next time, I can get that question right. You're trying to peak on exam day, not now. So if you're taking your simulated, if you're giving yourself time to take a practice test, it doesn't mean you're passing or failing. It's just a reflection of where am I at today? Focus on the mistakes you made because of the law and put those rules back in your head. Focus on the reading mistakes and really focus the next 6 weeks with your practice of slowing down and being more careful in not looking at it as a speed test, but looking at it as a reading test. That's what really this whole thing is. And the more you can fix these mistakes and these mistakes, ever so slightly, those numbers continue to rise. That's what you say when you take this, whenever your practice tests are. Close your eyes, take a deep breath and say, just read a little more carefully. And you will be shocked how many more points you're going to get. Good? Good. I'm going to see you again in a couple of weeks. Focus on the law. Focus on the reading comp. Don't be intimidated because it's a longer hypo. Don't be intimidated because it's a subject you don't like. Oh, I forgot to mention that. Sometimes when you're going through and you're piling up all these subjects and you feel good about tort, about crim law, those are actually the subjects you screw up more on the practice. And the subjects you don't like so much, property, contracts, since you're not really loving that, you just really just don't overanalyze. You just say, I don't know, that's what it said, so that's what I'm going to pick. You actually do better in those subjects. Why? Because you're not overanalyzing. You're not reading too fast. You're just reading it once carefully and saying, basically, I think that's what's going on. And you just shut up and pick it, and you actually score better. So sometimes if you're scoring worse on what you think are the easier or better ones for you, that's all reading comprehension. You're beginning to anticipate where these things are going, and you're not freaking slowing down and just being a little more careful. There's a sweet spot between too much and not enough. And for me, that sweet spot is I'm all in on the facts. Once I know, I go into those answers knowing what I'm looking for so I can shut up and pick it. Stay confident, stay aggressive. Time more is here, less time in the answer choices. Look at these like little puzzles and just do them one at a time. I do one, I throw it out, let them do the next one. You're basically taking 200 MBE exams. One question is not more important than the other. They all count for one. So don't give anyone too much credit. Don't ignore and skip any questions. I'm doing everyone exactly the same, and that's what I'm trying to do. If I can focus more on one question at a time, that's what I want to be able to do. Good? Good. Hope that brought you back to some fundamentals regarding reading comp. take them to heart, try to apply them to your questions this weekend, do fewer to rebuild your momentum or rebuild your confidence. If the lecture can help out there, the Mastering the MBE, I know it will. I hope it does. And please, of course, always feel free to stay in touch if you need anything. We'll look forward to seeing you in a couple of weeks for kind of a wrap up as to what you should be doing moving forward before the actual bar exam. Have a great weekend. Stay confident, stay aggressive. And you know what I'm going to say. When you know what that answer looks like, shut up and pick it. We'll see you soon. Take care.